This is week 6, Teach and Share, chapter 11, UCC contract formation and terms taught to my mom. So we've already talked about contracts, different type of contracts, everything like that. So back in 1945, the National Conference of Commissioners on Uniform State Laws started working on common contract language. So just common things that are found when you make a contract. And eventually that was changed and called the Uniform Commercial Code and is found in every state. And it just is set to simplify commercial transactions. So what we mainly focused on for this chapter was Article 2, which deals with the sales of goods. Does that make sense?
Yep.
So what it does is it fills any gaps. So we look to the contract first. If something's missing, then we go to the UCC to find what the answer is. If a provision can't be found, if something can't be found on the original contract, then we move to the UCC. So
Sounds good.
when it comes to the Article 2, this is set up to govern the contracts for sales of goods. General contract laws will still hold true unless it's been modified by the UCC. So the UCC only applies to the sales of goods, but that doesn't mean it applies to real estate, services, or stocks. Rules can also vary depending on whether or not one or both sides are a merchant. Does that make sense?
Mm-hmm.
So it's on goods sold. It's not like real estate. It's not services. It's stocks. So
my barbershop's not in there.
So it defines a sale as the passing of title or ownership from the seller to the buyer for a price. So gifts aren't sales, obviously.
Mm-hmm.
So a good is a little bit more difficult to define, but basically it's tangible and movable. So tangible means it can be physically touched, it physically exists. Movable means that it can be moved from one place to another. So you offer more of a service than a good.
Yep, I do.
So there are times when a contract has goods and non-goods, and we would have to use the predominant factor test to see if the sale is for the goods or the services. So we have to determine, is this contract primarily for sales, primarily for goods? So what comes first in it? Does that make a little bit of sense? So it goes on to define what a merchant is. So merchants will usually have a higher level of sophistication and would be held to a different standard than those who are ordinary or unexperienced.
Okay.
So like an everyday person. So merchants should know more than the everyday person. So the UCC defines a merchant as deals in goods of the kind involved in the contract. They hold themselves to having a special knowledge and skill in regarding the practices or goods involved in the contract. This will also employ a merchant as a broker, agent, or other intermediary. Does that make sense as to what a merchant is?
Yes.
So when an offer is made under UCC, parties will be allowed to include contract terms to which the parties agree. The rules about when payment is due will only come into play if they don't state as to when the payment is due. If it's not stated in the contract, that's when the UCC rules come in.
Okay.
So if there's missing, so like I said earlier, it's filling in the gaps.
All right.
Filling in the missing pieces. So in general contract law, a contract is formed the moment the offeree accepts the terms. While under the UCC, it changes it by recognizing as valid that some terms will be vague or open. So UCC means it can be accepted even if it's a little bit vague. Whereas contract law is like, no, you have to this, and this, and this. So under the UCC, agreement will not fail as long as the parties intend to make a contract and the court can find a reasonably certain basis for giving a remedy. So a reason to fix an issue that comes up with the contract. Does that?
Yeah, it does.
Yeah. Like I said, I was reading it this week and I was like, this is a lot of information.
It is a lot of information.
And my brain's going a little, what?
Contracts have a lot of information.
Yeah, they do. There's so much. Yeah. So under the UC, when it deals with the offer, there is a part called open terms. So if a price has not been agreed to by both sides, the UCC allows the court to determine a reasonable price at the time of delivery of the good. If the contract indicates that either side may set the price, that party must do so in good faith, which again all comes back to basically being honest.
Mm-hmm.
You can't do it if you're not being honest. You can't make fake contracts, in any circumstance. So when a price is not specified, the UCC indicates that payment is due at the time and place which the buyer is to receive the goods. And also, when there is confusion about the duration of the ongoing contract, either side can terminate at will. The only restriction is that both treat each other in good faith. So again, always comes back to being honest and being fair to each other. So open quantity terms is a bit more complicated. So this is if the parties fail to state the quantity of the good in the agreement, it's likely that the agreement is not real. So it's not valid. You have to give it. I'm giving you this amount of trucks or whatever the good is.
See, this actually applies to my business when I
So
sell
this yes.
because I will be selling my clientele list, which
Yes.
is the good faith.
Yes. So the two exceptions to the open quantity and quantity terms is requirement contracts where the buyer agrees to buy and the seller agrees to sell all or up to a stated amount of what is needed or required.
Okay.
The other side of that is output contracts where the seller agrees to sell and the buyer agrees to buy up or all a stated amount of what the seller purchases. This the word produces limits the exception to production contracts than resale agreements. Due to the seller forfeiting the right to sell goods to another buyer, there is implicit consideration built into this contract. So you cannot go and try to sell to somebody else if you've made this contract.
Yeah.
You have to.
Makes sense to me.
So the merchant's firm offer, when we deal with that, is the UCC will create an exception where a merchant offers to sell or buy goods. So if a merchant offer, the one offering guarantees or promises in a signed writing to keep an offer open, then the offer by the merchant is valid and can't be revoked. It has to be signed by the merchant and be written. No consideration is required, so merchants should be held to their word. So user consideration, you have to do that.
Yeah.
With that, the UCC indicates that offers can have a specified time, or if no time is indicated, then it will stay open for a reasonable time, but it can't exceed 3 months.
Okay.
So it's reasonable up to 3 months. Anything past that, it won't work.
It's not reasonable.
Yep, exactly. It goes past that, and the UCC goes, no. So basically, it's like the UCC is a code that will fill in the gaps when you make a contract. When it's dealing commercially, though, this is commercial, side only. This is just the part. There's more to it, but this is specifically one part.
Article 2.
Yep. So acceptance under the UCC can be given in any reasonable manner. It does not use the mirror image rule, so you can actually counteroffer in this. Where with general contract laws, you can't. So it allows to be formed if the offeree's response shows a definite acceptance, and even if it includes terms that were added. So, like I said, counteroffers can be done with this, whereas general contract they can't. So if those, add-ons, different terms, whatever the case is, are incorporated into agreement, they depend on whether one or more of the parties are merchants. If non-merchants, it goes back to the original offer and is rejected. So it all ties in. You have to be merchants. Both have to be merchants. So consideration under the CCC. So these are the same under both common law and the UCC. Exception is that modifications of agreements under this do not require consideration like they do under common law. Okay. So it's a little bit more, there's a little bit more freedom, but still kind of, you have to do decisiveness.
There's steps to follow.
So statute of fraud requires that certain agreements must be proved by writing. So again, it all comes down to, you have to be able to prove what was going on. So any writing will be sufficient to meet the requirement as long as it's clear that both sides intended to enter the agreement and is signed by the side against whom the enforcement is being sought. So again, it can even be on a napkin or a random piece, but it has to be written.
Okay.
So contracts between merchants are, with both sides are merchants, then the court will enforce an oral agreement if after coming to that one of the sides sends a signed confirmation to the other within a reasonable time. So again, the courts will look to, was it signed, was it written, what is all going into the consideration of accepting the offer. So confirmation must have the essential terms of the agreement and the rationales that the merchant will reject if it's inadequate or incorrect. If it doesn't recur within 10 days, then the court will enforce the agreement against the other side, even though it was not signed. So again, there's time frame, consideration, all of that. Does that make sense?
Yeah, it does.
It's a lot. Like I said, it's so much information. But I was like, oh, well, this makes a lot more sense, especially if you're going to be dealing in, like I want to do an event planning business. I'm going to be working with merchants and stuff like that. So I have to understand these guidelines.
Yeah, you do. That's for sure.
So exceptions, the UCC will discard the writing requirement when admissions. So that means when the side being sued admits that the contract exists, then they can't rely on the statute of frauds to argue that no contract exists. So they can't, it's that you can't say one thing and then go behind and change your back and do something else. If partial performance occurs, oral contract for the sale of goods is enforceable if payment has been made and accepted, or if the goods have been received and accepted. And then the parole evidence rule, which I always keep forgetting. I was like, what was this again? So this is set up to keep another side from talking about what was said before or during the signing of the agreement. So you can't talk about it. Mm-hmm. So it's like if you have a settlement between two companies, you can't talk about what was in there before or during the signing of the agreement, because that's technically a breach of contract, and that's no.
So does that apply to the fact that I'm not allowed to talk about my contract? It's in my contract with my leaseholder.
Yeah,
but I can't talk about it.
You can't. No. Okay. That's general contract law, but it still applies to this parole evidence rule is in general contract law and the UCC. Okay. So it's crazy.
It's a lot of information.
It is a lot of information, and a lot of people don't know what this is. So
that's why attorneys make money.
Exactly. That's why attorneys make money. And I thought it was interesting, like I said, that for my event planning business that I would need to know this type of, these codes. But also, it says it's found in every state. So my thinking is that I want to do more reading on is if it's countries have something like the UCC set up. So if you're having trade agreements, are there going to be a code set of rules?
Yeah, and you're probably going to have to watch because some countries change their laws a lot.
That's something that was discussed in our international politics class. It was like agreements will happen, but that doesn't mean that all the time that they're going to be held.
Yeah, some countries rewrite their constitution almost every 3 years.
So I was like, if there's the UCC for states, I'm like, is there something for countries worldwide? So I'll have to do more research on that, but that's what the UCC is.
Universal Contract Code.
It's a lot of information.
It is a lot, but I'll remember.
Yeah, you're like,
There's some good information in there.
Yeah. So I'm glad you learned, because I learned. Thank you.